Hi, it's Don McLaughlin from Falcon Discovery here at Legal Tech 2012. I am pleased to introduce Nicolas Economou from H5 Technologies. Nicolas, if you just introduce yourself, great to have you.
Thank you, Don. So I'm Nicolas Economou. I'm the CEO and founder of H5, an information retrieval firm based in San Francisco.
Tell us a little bit about your background and the work you're currently doing with H5.
So I co-founded H5 about 10 years ago with two partners to commercialize an information retrieval technology directed mostly at the legal industry. The heart of H5's proposition is that we help clients, corporate and law firm clients, solve really complex search problems. And that means in practice finding responsive documents, finding hot documents, designing and executing processes to identify and sometimes discard non-responsive material that exists in archives, and so on and so forth.
Fantastic. You know, going back 10 years, the founding of H5, what have you seen over the last number of years in the way courts and practitioners manage e-discovery as a process and information governance? What do you think is improved in the process?
I think the main changes, beneficial changes from my perspective, is first of all a recognition that this is a very large problem. The data explosion is a large problem. Secondly, the adoption of a limited but at least common framework in EDRM. Thirdly, I would say the development of a class of professional administrators of e-discovery processes, both in law firms and corporations, who understand each of the components. And I would say around that also a real core of professional advisors and consultants, I guess, such as yourselves, who can really bring battle-tested processes to e-discovery where before they did not exist. I think with respect to courts, there is greater attentiveness being paid to this problem because of its magnitude, because of the delays it causes and the shenanigans that often exist in discovery. And I think there is an evolving understanding that this is a field that screams for better standards, better processes, for greater attention from the courts. So that's what I would say has been the main difference between then and now. And at the heart of this is, I think, an understanding that technology that created the problem is the cliche, is an indispensable part of the solution. And I feel that the industry, participants, lawyers are now less concerned about the incorporation of technology in their processes than they were 10 years ago.
Well, that's I want to ask you the flip side of that question, which is, what do you think courts and lawyers and practitioners can continue to do to improve the process?
So I think for me the biggest missing component to all this is that, from my perspective, the nature of the problem is still fundamentally misunderstood. And what I mean by that is that discovery is seen as a legal challenge primarily, or as an IT challenge. And I think it is true that it has, it's a process in pursuit of legal goals and has a very strong IT component, but the nature of the challenge is really different. Scientifically, it's a search problem. And that takes you to computer science, to statistics, to linguistics. And I believe that as long as you don't acknowledge this challenge as a search challenge, you're not looking for answers in the right academic and scientific areas. And once you do, you find that a lot of the solutions that courts and litigants look for, in fact, pre-exist in this domain and have been applied elsewhere, but are not being taken advantage of to solve some of the most vexing e-discovery challenges. So I think there has been some progress in this respect. We've seen that NIST and TREC have come into the fray, creating a forum where search methods for responsiveness review are now evaluated. We've seen some judges write articles and write about how this is really a search problem and so on and so forth. But that hasn't permeated in the consciousness, I think, of the industry and of the court system. And I think unless that's done, this emerging industry really doesn't have a field around which it can truly consolidate from a scientific perspective.
Do you see that shift happening, and are you guys picking up on a trend in that direction? And if so, in what ways? And if not, what do you think are some of the hurdles to that shift?
Yeah, so I think the shift is happening a little bit by necessity. Again, I mentioned some judges have issued some opinions that are fairly well known, where they start to allude to these fields of expertise that should be brought to bear. We've seen, again, TREC having these forums every year. And generally, people talk about these problems as search problems, but I don't think everyone understands exactly what in academia constitutes search. Now, I think what is most needed once you recognize that the nature of this problem is search, is in fact to create a judicial framework to assess these search questions. Today I would say there's very few corporations or law firms who can answer what the search expert would deem to be the two basic questions of completeness around the production, which are how accurate was your review and how do you know? You can't answer these questions meaningfully unless you have a statistical framework to answer those, and you won't really think to answer these questions unless a judicial framework imposes them. So these two things are intertwined, and so I think again we see courts paying attention to that. My hope is that over the next year or two, and I think that's what we'll see in 2012, is the emergence of a judicial framework like that, and possibly actually the emergence of some set of certification standards that will allow courts to say, just like if I admit an attorney, a lawyer in my court, it's because they've at least passed the bar. Well, I'm trusting that the party is competent to do search because they've passed some bar, some certification in terms of their competence in finding what's relevant and leaving out what's not relevant.
Your work at H5, how do you see you all helping to address those problems you're talking about and help lawyers and judges understand the need for that framework and the application of the technology?
So on the public policy level, because I do think it's a public policy problem, we're really working closely with a lot of industry participants, with the Sedona Conference. We have supported the TREC efforts for a long time. With everyone who's interested in this problem, we have a very active dialogue to see how the expertise, the experience, the field of search can be brought to bear on these questions. Specifically with clients, we have and provide expertise every day, not only in executing complex searches, finding hot dogs, preparing the position kits, finding gaps in production, conducting responsiveness review that is measured for accuracy and so on and so forth. But we also help advise clients on a day-to-day basis how they need to think about defensibility. What does it mean, defensibility, in the age of technology-assisted review? How do you know that your production is complete? How do you answer these questions of how accurate was your review and how do you know? So we help train law firms, we help train clients on answering these questions effectively.
The broader topic of information governance, how do you see your work contributing to that problem of information governance when information seems to be multiplying exponentially year over year?
Absolutely. So information governance is the largest underlying problem. Really, what do you do with information before it becomes a problem? From our perspective, this has the same characteristics as any other search problem. How do you define the institutional perspective of a corporation on what they should keep and why, and what they can set aside or discard? And how do you then, once you define that very accurately, then how do you apply this institutional knowledge in a systematic, methodical way, in a consistent way, across pre-existing data and across new data? Without going into detail, many of those answers are to be found in the field of search, which we have in fact tried to, at an industrial scale, provide to our clients in the field of information governance and litigation, and we have in the past, in fact, solved some of these challenges for some of the largest corporations in America.
Terrific. So while we're at Legal Tech 2012, what are you looking to pick up on in terms of either educational sessions or things on the conference floor in terms of other technologies? What things are you looking at this year?
So I'm very interested to see that there are more and more companies, which was not the case 3 years ago, that associate themselves with search, many more vendors of search tools. And I think that's a very good trend. I think it reflects the broader understanding that this is going in the direction of being understood and solved as a search problem. Our view as an aside is that the search tool alone is not sufficient. You really have to have the expertise to deploy it, implement it, and measure it. Otherwise, you're using a scalpel, so to speak, without being a practitioner of being a doctor. So to me, it's interesting to see that, and I'm looking for developments on search technologies. I think with respect to the panels, I'm very attentive to what judges say, because I think that what they say here very often kind of foreshadows what might be discussed in the industry over the next year.
Terrific. Well, it's a pleasure talking with you. Thanks very much, Nicolas.